So we move to our closing remarks, our concluding remarks for the conference. And first, I would like to give the microphone to Professor Richard Steinberg of the UCLA School of Law.
Thank you. I think we're not going to take nearly the half hour that was scheduled for these concluding remarks. I'm going to be very brief. But I do want to try to do some summing up, because there was always a risk that the conference would be perceived or would conclude with a sense of disagreement or broad disagreement. And I think that, in fact, I have been very pleasantly surprised by the extent of agreement in the room. And since virtually all of the stakeholders are here, this is very promising to me. So I want to try to just sum up with 6 points of, I think, crucial agreement. The first is that national judicial systems must assume a greater role in prosecutions and at a much greater scale than is currently taking place, and that this will require capacity building in terms of scale to prosecute. This will require money and a better understanding of what national jurisdictions need in terms of their own system. Second, access to tribunal information must be improved and maintained. Physical archives must be in one secure place with proximity to the residual mechanism and fully translated into BCH. Information centers will be useful and important symbolically. There was almost complete agreement on that. The digitized version has to be searchable. It has to be accessible with a shift in the architecture of the website, and some of the architecture should be in a narrative form. That is, some of the information that, of which the appellate chamber has taken judicial notice ought to be aggregated to tell a more clear story of what occurred. This information will never be a complete history, but is a partial history, and there has to be a process also for declassification of these documents over time. Third, of course, there must be a residual mechanism at a minimum to maintain information, to maintain a courtroom for the two fugitives, and for reviews. Fourth, the jurisprudence of the tribunal, particularly its substantive law, should spread appropriately, as appropriate to other jurisdictions, and there's a shared responsibility with both national engagement and international engagement for development and application of the tribunal's substantive law. Without this engagement, each jurisdiction, we risk, will go its own way. Fifth, all of this suggests that we are engaged in a long-term campaign, not a battle. It is too early for the international community to merely get out. Money and expertise and technology and political engagement are all needed from the international community, particularly from the European Union, if the tribunal's legacy is to be properly utilized for the region and the world. I can see the EU folks chuckling at that. And all of this suggests that a proper vision of the tribunal's future is not, as I've heard so much in the last 2 days, that it is closing down or winding down, but that it is transforming institutionally. Whatever the diplomatic language of closing down or just surviving with a residual mechanism, the model must be one less of dissolution and liquidation like Lehman Brothers, and more like looking at NATO at the end of the Cold War, which, when its raison d'etre disappeared, it transformed itself, it changed its mission, and the national governments that were constituent members had to change their institutions and change their mission as well. So too must the tribunal transform itself to more effectively distribute information and maintain it, and neither it or other institutions must be supported in their transformations so that they may begin to assume new functions, such as prosecuting the many perpetrators and employing the jurisprudence of the ICTY. I'd like to end by thanking a few people. First, of course, I want to thank Senator Diana Jenkins for her support of this and other human rights projects. Second, I'd like to thank the panelists and moderators. We're all grateful to your thoughtful participation. It's been an enlightening conversation. And a brief note to all panelists and moderators, the summary of your interventions will be published in a book by Martinus Nayhoff, and we will be contacting you by email in the next several days with information on our editing process and an explanation of your role in it. I'd like to thank the rapporteurs for the conference, the 10 people in the front row house left who have been furiously typing away the last 2 days. They all have carpal tunnel syndrome, I'm sure. As well as James Field, the Associate Director of the Senator Diana Jenkins Human Rights Project, who was invaluable in putting this together. I'd like to thank, of course, the prosecutor, Mr. Brammertz, for his partnership in helping organize this event. The registrar, Mr. Hawking, whose staff was continuously quick, efficient, patient, and thorough. And perhaps most importantly, I wish to thank Chambers. Judge Marone, with whom I first talked about this conference a year ago and who introduced me to President Robinson. Two of his staff, President Robinson's staff, deserve particular thanks. Gabrielle McIntyre for her humor, grace, wit, and effectiveness in the planning. Matthias Hellman, without whose hard work, bright ideas, and effective execution, this conference could never have happened. And of course, President Robinson, whose vision, willingness to partner, and his trust have been key to our collaboration. Thank you.
Thank you, Professor Steinberg. Now we will hear from Dr. Ernst Hirs-Ballin, Minister of Justice of the Netherlands.
Your Excellencies, President and members of the ICTY and the other courts that play a role in doing justice to victims. I appreciate especially that the perspective of the victims played such an important role. Ladies and gentlemen, it is so good to have you all here together at this conference here in The Hague, and I'm especially grateful for colleagues from the states involved in doing justice are present and participated in the panel and the conference today. It is an honor to be here to discuss the important issue of the legacy of the ICTY, a legacy which leaves us a foundation to build on in the future, and a legacy that imposes on us an obligation to keep its spirit alive, not only bringing the perpetrators of international crimes to justice, but also acknowledging the interests of the victims of these crimes. The ICTY was created at the beginning of the 1990s in an era of renewed hope and opportunities for the development of international justice. And I remember the day in November 1993 when I took part in the inauguration of the tribunal here in The Hague. The Berlin Wall fell in 1989, and a few months later, in February 1990, Nelson Mandela was released from prison. On another occasion, he spoke the words, we must use time wisely, and forever realize that the time is always ripe to do right. Despite the atrocities in the decennia that followed in the Balkan, Rwanda, and Sierra Leone, the international community in that same decennia also seized the opportunity to do right. It created the ad hoc tribunals and the International Criminal Court, and meanwhile, the International Criminal Tribunal for former Yugoslavia performed a tremendous task. When reflecting on the tribunal's legacy, it is not easy to choose one or another achievement in the face of the work that has been done by the ICTY and by other international tribunals the past 17 years, work for the victims, work for the development of international criminal law, work for justice. An important achievement is that the ICTY has brought the investigation and prosecution of war crimes, crimes against humanity, and genocide into the modern era. Before the creation of the ICTY, the efforts in this field dated back mostly to the trials of Nuremberg. We have seen through the work of the ICTY that the investigation and prosecuting of such crimes demand a considerable amount of time, effort, means, and commitment. However, the ICTY demonstrated to the world community that these cases are in a sense criminal cases that can and must be adjudicated. Reflecting on the legacy of the ICTY, the lasting legacy in the Balkan region comes to mind. Justice, in this sense, is the key to long-lasting peace and reconciliation. The ICTY went beyond its original mandate by contributing to the creation of regional judicial mechanisms to deal with the past. This contribution to the national prosecution and adjudication process is a major contribution to lasting peace in the region. When one thinks of the legacy of ICTY, one thinks also of the formidable corpus juris built by the eminent legal experts that working at all different levels and organs of the tribunal. The rules and case law contained in the archives of the tribunal is yet another achievement which will assist and guide national and international practitioners for years to come. It is essential that these archives remain available to these practitioners in the future. Reflecting on legacy may, however, almost lead